State Attorney, Sefako Bache, expressed frustration over the delay, noting, forgive me, that the prosecution's first witness was ready to testify. The case involves Professor Christopher Amia Konfi, former GIIF board chairman, and Solomon Asamoah, the fund's former chief executive officer. The two have been charged with causing financial loss to the states over their alleged roles in the disbursement of funds towards the SkyTrain project. Now, this evening, we want to find out whether or not one can really go to the law court when facing charges alone, or whether he or she has to get a counsel or a lawyer to represent him, and whether this case can really start or be tried. The trial can really begin in its absentia, and for that matter, putting the judge to issue this caution. Joining us via Zoom this evening on Newsnight is a private legal practitioner, Richard Niyama. Counsel, good evening. Welcome to Newsnight.
Good evening, Mr. Speaker.
Well, good to have you. Now, if I had a case at any of the law courts and I go there without a legal counsel, what does that mean to me as a person being charged with some issues and facing trial?
Well, Mr. Speaker, you have every right to represent yourself without a lawyer. And so it is not compulsory that when you are charged and put before the court, you must necessarily have a lawyer. You have the right to any lawyer of your choice, but you also have the right to represent yourself. And this is perfectly captured in Article 19 of our Constitution. So with your permission, I'll read a few portions of Article 19. If you read Article 19(1), it says that a person charged with a criminal offense shall be given a fair hearing within a reasonable time. Then you look at Article 19(2)(e). Let's go to 2(e), F, and G.
Yeah.
2 says that a person charged with criminal offense shall be given adequate time and facilities for the preparation of his defense. So the first thing is that when you have been charged with a crime, the law says you should be given adequate time and facility to prepare your defense.
Yeah.
When you go to 2F, it says that a person charged with criminal offense shall be permitted to defend himself before the court in person or by a lawyer. So in person means that you can decide to defend yourself. And it happens all the time. In fact, a lot of people go to court without a lawyer. The law is saying that you can defend yourself in person or by a lawyer. Then we go to 2J, Article 19(2)(J).
Yeah.
It says that a person charged with a criminal offense shall be afforded facilities to examine. Again, here too it says in person or by his lawyer.
By his lawyer.
The witnesses called by the prosecution before the court, and to obtain the attendance and carry out the examination of the witnesses to testify on the same conditions as those applicable to witnesses called by the prosecution. So usually in prosecution, the prosecutor will call some witnesses to come and testify against you. Article 19(2)(J) here is telling us that either you, the accused person personally, or your lawyer should be given the chance to cross-examine the witnesses who are coming to testify against you. And so whether you have a lawyer or not, the court will go on. Of course, a lot of the time, the court gives deference to the right of the accused to get a lawyer, because the courts are very much aware that for most people, when you are given the chance to cross-examine a witness, you may not be able to ask the right questions because you may not understand the law enough to be able to ask the questions that will expose the weaknesses that are needed to defend your case. And so when you have a lawyer, it gives you that upper hand to be able to ask the right questions that will expose the witness if indeed the witness has come to lie against you. But that does not prevent the court from deciding to proceed with a trial if you don't have a lawyer. And so most of the time, if let's say you have sacked your lawyer or your lawyer has died or resigned, the court will give you 1 month or 2 months to go and look for a new lawyer. And if after some time you are still not able to produce a new lawyer, the court will continue the case as if you had a lawyer.
Now you would want to help us understand this. So why would the trial judge caution, in the case of Professor Ameya Kumfi, caution him when he appeared before the court and without his legal representatives?
Well, the judge might have a lot of things on his or her mind at the time of questioning him. Because I'm not in the judge's mind, I'll just be speculating. Some of the things the judge may be thinking about is that maybe Prof wants to use the lack of a lawyer to cause unnecessary delays in the case. Because there are some accused persons who you may give them the chance about 5 times, 10 times, they'll go and come back and tell you, my lord, I've been looking for a lawyer. I just found a lawyer yesterday. He said he would come, he didn't come, that kind of thing. And then that will be used to delay the first time. Other times too, the person is really not looking for a lawyer, but he's just, using it to buy time. And so if the judge is of the opinion that you are wasting the court's time, the judge will caution you because, as I've read to you, having the lawyer is a right, but it is not a requirement for trial.
Okay.
And so if the judge decides that the trial is going to proceed without your lawyer, you must come and question the witnesses yourself. If you remember the Republic versus Tashuchikata, I think sometime in 2008 or 2007, the judge was about to give her ruling, and Mr. Tashuchikata said that his lawyer was not in court, and so the judge should allow him to go and get his lawyer. The judge refused and went ahead to grant the ruling and put Mr. Chikata in prison. And so these things, they happen every now and then. If the judge is of the opinion that you are just using the lack of lawyer to delay the court, then the judge will want to proceed without your lawyer.
At what point would a trial happen in someone's absentia? Because if in this case, the judge warned that if he fails to appear with his lawyer, he would proceed in his absence.
Okay, so for trial in absentia, we are looking at Article 19.3.
Yeah.
Okay. Now, when we look at Article 19.3, it tells you that the trial of a person charged with a criminal offense shall take place in his presence unless, you see, it says the trial of the person shall take place in his presence unless. Then they give two options where trial in absentia can take place. Number one, he refuses to appear before the court for the trial to be conducted in his presence after he has been duly notified of the trial. Okay, so let's take Prof's case, for example. Prof was already in court when the court gave the next court date. So he's aware the next date that the court is going to set. If he decides not to come, the court will take it as he has refused to come because he was there and he himself, he has decided not to come. Therefore, trial can continue in his absence. Now, there's a second condition. If he conducts himself in such a manner as to render the continuation of the proceedings in his presence impracticable, and the court orders him to be removed for the trial to proceed in his absence. So there are some people, they've been charged with an offense, they come to court, and sometimes the way they behave makes it impracticable for the trial to continue in their presence. For example, they are banging on the table, they are making noise, they are shouting, they are cursing the judge and the police officers and making the courtroom ungovernable. When you go to court and you put up such a behavior, the court can order that you should be put in prison while the trial goes on in your absence. Otherwise, at all times, an accused person must be present while trial is going on, because it is about your freedom and you need to be interested in the evidence that is being led so that there are times that your lawyer may be asking some questions that you yourself, you realize your lawyer is doing the wrong way because you are the one who knows the facts. If you are in the courtroom, you can draw your lawyer's attention and say, counsel, please, this is what happened, this is what happened. Then it will guide your lawyer to ask the relevant questions that will help your case. So every accused person is entitled to be in the court anytime the trial is going on.
Now, if you read from or if you listen to what the chief state attorney talked about, clearly there seem to be some delays. Now, these delays, does it really occur as a result of the fact that the accused tries to one way or the other drag his or her feet, trying to follow legal proceedings, or most of the time is from the court or the prosecution?
Delay can come from every quarters in trial. There are times the court will give you a date. By the time you get to the court, the judge is sick. And once the judge is sick and he or she did not come to court, whether you like it or not, you need to take a new date and go and come. So the judges themselves can cause delay. Sometimes the date that the trial is supposed to take place, that is the date that the chief justice will set for certain meeting to happen or a certain training to happen. You get to the court and the registrar will tell you in the morning that today the court is not sitting. That can cause delay. Secondly, the prosecution can also cause delay. Sometimes the prosecution has been ordered to come and file their disclosures or the witness statements that they are going to use against you. They will come to court first time, second time, third time. They have still not been able to file their disclosures. And so the judge or the court is compelled to give them time. Sometimes the judges will threaten them that if you don't come and file in time, I'm going to, quash the case and discharge that accused person. But a lot of the time it doesn't help because even if the judge decides to dismiss the case, the prosecution can just use the police to rearrest the person and rearrange the person before the court again. And so even those things sometimes doesn't help when the prosecution is causing delays. There are times they will come and tell you that Attorney General is conducting training for all its prosecutors. And so you come to court and no prosecutor will come to court. That one too can cause delays. There are also times that defense lawyers will also fall sick. And because of that, prosecution cannot take place. Or defense lawyers can travel. Or defense lawyers can even file frivolous applications, knowing very well that those applications have no merit and they are going to lose. But they are only filing it just to cause delay because maybe they know their client is guilty and they don't want the trial to proceed so that their client will go to jail. So as for delays, delays can come from all angles. Now, the other one I'll add to delays is that the country itself does not have enough courts or adequate courts. Yesterday, I was on a radio station, and as I was telling them that we do not have up to 500 courts in Ghana, they went on Google and they confirmed to me that the number of courts in Ghana is 380 something. Okay, so look at the whole Ghana with less than 400 courts. I was even saying less than 500 courts. With less than 400 courts, and look at the number of cases that are going to the court every day. The judges are so overwhelmed. Sometimes something that the judge is supposed to give you an adjournment for just 1 week, he has to give you about 2 months because when he opens his diary, the diary is so full that there is no available date until the next 2 or 3 months. As I speak to you now, we are in October of 2025. If I open my online diary to you, you will see that I have some cases that have been booked for as far as June 2026. Because when we went to court and we were taking new dates, the judges don't have enough available dates in their diary. So they have to send us as far as their diary can accommodate. What it tells us is that the country needs to train more lawyers and recruit more of them to become judges, build more courts, and employ these judges into these courts for them to come and speed up the adjudication process. In fact, even with the few courts that we have, because of financial clearance, there are some places when you go, there's one judge who is conducting cases in 2 places. So I can give you a typical example. When you go to Ekwapem South, The same judge in Mampong District Court is the same person who is the judge in the Every District Court. Sometimes I cry for her because she goes to court on Mondays, Tuesday, Wednesday in Mampong. Then she will close the Mampong court and go to Every Court on Friday and Thursday. So why would there not be delays in adjudication? If we want to avoid delays, I am calling on the government of Ghana to put more money in the judiciary, build more courts, and recruit more judges. When there are enough judges in the system, the delays will reduce drastically, and there will not be complaint about delays in trials.
Now, very interesting point you are making out there, Council. In this country, we have about almost 200 lawyers or more, 800 lawyers graduating from the law school and being called to the bar every year. I think I'm right.
You are right, Mr. Speaker.
So
I think the last count, it was 8,000 lawyers, but it has never been the norm. That is the highest that has happened in recent time. It was always less than 200 a year.
Yeah, this time it was about 800 or so. So when we have a country where about 800 people are called to the bar, so let's even make it average. Averagely, about 300-400 people are called to the bar every year, and we have this number of courts with this number of judges. One expects that at least with this number of lawyers who are really being called to the bar every year, it would also facilitate in adjudicating issues quite expeditiously. Here we are with this challenge. How do we merge the two and say that, yes, indeed, because we have this number of lawyers practicing in Ghana and this number of courts, when one's case comes up, it would be handled expeditiously? Are we not failing? Is the judiciary not failing in that direction?
Mr. Speaker, since this was not part of the discussion, but let me just chip it in. You see, the 800 lawyers that were called recently, I believe is the highest number we have ever called. Okay. It will surprise you to note, me talking to you, I was called to the bar in 2021. Okay. My bar number is 7935. It means I am 7,935 lawyer to be called since Kwame Nkrumah's time. Since Kwame Nkrumah's time, our bar numbers don't change. They give you your bar number, it is for life, you die with it. So if me sitting here, I was the 7,000th lawyer to be called in Ghana, you can imagine the number of lawyers we have in this Ghana, because some of them have died and the bar number is not replaced. Even with the 800 who were called recently, if you go and check the total population of Ghana Bar Association, I checked it about two days ago, it is still less than 9,000. The total population of members of Ghana Bar Association is still less than 9,000. Divide it to over 35 million people in Ghana and check whether we have enough lawyers in the country. So a lot of people are making noise out of ignorance and saying that Ghana is producing too many lawyers. But in actual fact, we do not have enough. And that is why we don't have enough judges, because it is only lawyers who qualify to become judges. If you don't have enough lawyers, you can't get enough people who qualify to become judges for you to appoint them onto the bench for them to come and help to speed up adjudication.
Agree with me that at least
if there's anything
you would agree.
Also,
you would agree with me that at least for now we have not less than 6,000 lawyers, obviously alive.
About 9,000.
About 9,000. And so
yes.
Can't we?
Out of that 9,000, some of them are judges.
Mm-hmm.
Some are working in the corporate sector, so they don't do litigation at all.
Yeah.
Others, they are just lawyers and they have become politicians. They are just using the titles. Others too have traveled out of the country and their name is in the roll of lawyers. So if we really want to look at the number that is available to practice, it will be less than 5,000.
So then,
35 million people.
Can one argue that it is not the judicial services fault that we don't have enough judges? Because looking at the calculation you have just done, I mean, if lawyers are the ones who will be called or who will be at the bench and we don't have enough lawyers, then clearly it's possible we are also not going to have enough courtrooms.
That is part of the problem. But of course, it is not judicial services' fault. The other part of the problem is the government of Ghana, because you can't employ judges without financial clearance in this country. I have been advocating that we should cancel that system where if the Chief Justice wants to appoint more judges, they have to go and seek financial clearance from the finance ministry. It doesn't make the judiciary independent, because it means that they must play subservient to the Minister of Finance in order to be able to get their financial clearance to employ the number of people they want.
Yeah.
I think that if we really want judicial independence, we should create a percentage of our GDP or our revenue and say that every year, this is the percentage of our revenue that must go to the judicial service. If the judicial service is going to employ one judge or 1,000 judges, it is their own matter. That is the money the state is giving to them. The finance minister cannot decide I'm increasing it or I'm increasing it. Okay. Once we have a system like that, we can have that independence for the judicial council itself to sit down and say, okay, looking at the system, we need this number of judges we are going to employ. We don't need this number of staff. We are not going to employ them. We want to build more courts, or we are not going to build more courts. Then they will be independent, and they will have some assured amount of money coming to them that they can always use to invest into the judiciary of the country.
All right, Council, thank you. But let me come back to the earlier conversation that has to do with that caution given to Professor Christopher Ameya-Kofi. You talked about the fact that one can appear before the judges without a lawyer. Is it a safe decision to make?
Mr. Speaker, it is just like asking me that your car tire is flat in the morning and you have your own pumping machine at home. And then you are asking me whether it is safe to pump it yourself or you have to take it to the organizer. The answer is obvious to you. You can decide to pump it and take the risk.
Is it a safe decision? Because I believe you also understand the legal jargons. For me, I may only be good at questioning, but I may not be able to understand how well to really express myself at the law court. And if you think you are involved, and for that matter, you can handle your own case, would that not be a high risk decision to take?
Of course, it is a high risk, and it depends on even the crime and the circumstances surrounding the crime. And so there are certain cases, for example, murder. Okay, if you are charged with murder and you go to court and you plead guilty, normally the judge will enter not guilty for you. The reason being that murder carries a maximum penalty of death by hanging. Of course, we know that we have not been killing those who have been sentenced to death, okay? But because of that, when you go and plead guilty, the judge will normally enter not guilty for you, even though you yourself, you said you are guilty. Number two, if you say you don't have a lawyer, the judge will most certainly refer you to the legal aid, for legal aid to come and defend you. The reason is that the crime that has been put upon you is so heavy that if you just go and plead guilty and the judge has to sentence you, the sentence can be very catastrophic, okay? So, but when we look at Professor Ameya-Kofi's charges, I think they are charges that have to do with financial misapplication and so on and so forth. Normally, these things, the penalties are not that serious. So if you go and say you are going to defend yourself without a lawyer, the judge will not bother him or herself to get you legal aid, because after all, you may go to prison for just about 2 to 5 years and come back, okay? That is why I'm saying, yes, you can decide to go to court without a lawyer, depending on the type of crime that is involved. But of course, it is always the best and the safest to go with a lawyer, because number one, the lawyer has a wealth of knowledge about the procedures. Sometimes it's not just about the law. One thing people don't know is that when we come on TV and radio and we are discussing the law, we only discuss the substantive law, okay? But in the courtroom, it is not always the substantive law that works. It is the procedural law. And I cannot come and sit on radio to discuss procedure, because it will be boring to everybody. You may not even understand it, okay? And it is the procedure that can either send you to jail or not. And so it is always better to have the lawyers to defend you in court
Okay.
if in fact you don't want to go to jail.
All right. Counsel, thank you. And once again, most grateful for your time on Newsnight this evening.
Thank you and enjoy your evening.
So that was a private legal practitioner, lawyer Richard Niama, speaking with us on a case at the High Court here in Accra involving Professor Christopher Amia Ekumfi, a former board chair, Ghana Infrastructure Investment Fund, and he's being charged with causing financial loss to the state as far as the investment of funds towards the Sky Train project is concerned. Well, Newsnight will take a break. When we are back, the secretary to cabinet has issued a warning to ministers of state not to announce policies without